Welcome everybody. It's great to be back.
We're back.
You missed us, didn't you? It's I took a vacation, so I think Greg and Aaron took a vacation too. I think that's.
We took a vacation from you, Chuck.
That way, well, you have to ask my wife. You got to do that occasionally. Take a girls' weekend away. But I missed you guys, and I missed, of course, the folks that watch us and our clients. But we have had, this has been a crazy couple of weeks. In the litigation group here at Impact Litigation. And we're going to talk about that. But Aaron, I want to start with DV 2022 because it's quite clear that Department of State is not going to issue these visas. They that goes to the other DVs we'll talk about in a second, but it's quite clear they've only basically did an additional almost nothing burger in January. And the interviews that have been set out, they pale in comparison to the available visas. And it looks like, because they're already setting some appointments in March, it looks like they will get to the midpoint of the year on March 31st and have issued less than 6,000 or 7,000 visas.
Yeah, I mean, right now I'm looking at the statistics on from the folks over at SaveDiversityVisa.org who take it from the SEAC website. And as of yesterday, there have been 1,097 visas issued through January.
I mean, that's unconscionable. It's absolutely unconscionable.
Chuck, they told Judge Mehta that they were working really hard to get all these cases done.
Yeah. This is going to look so good when we file this lawsuit. This is going to look so
What we're talking about is in the DV 2021 litigation, the judge has already issued an order to issue a certain number of visas, and the government has to tell the judge periodically what's going on and why they're not abiding by that order yet. And they have indicated that, one, they have software issues that are not going to be resolved until April, but not to worry because they were front-loading DV 2022, getting all those visas out of the way so that they would have plenty of resources available to work on the judge's order in the latter half of the fiscal year. So this is puzzling.
So that means, Greg, they would have issued 26,000 visas by end of month.
Well, or at least be on a kind of a pace to issue a lot more than they have. I mean, if it's possible that they have been getting ready a lot to interview, but there's no indication that that's happening.
So there we are. So our litigation, which is set up here for DV 2022 delays. We're still accepting plaintiffs. And Aaron, where are we kind of looking as far as filing? Do you know?
We had originally thought that we might file by the end of January. That's obviously got pushed when we extended some deadlines for people. But I would still like to file this next week. I don't know. I don't think we have a hard deadline, but what we wanted was the data to become clear. That they are not administering the program in good faith. And I think we've got it. I think we've got enough data. And so I'm ready to push ahead with the plaintiffs we have and draft this lawsuit with the idea that we'll aim to file by the end of next week.
One thing that's become interesting to me is I've gotten several DMs and emails recently from folks from DV 2021. Said, hey, I didn't get my visa. How can I work with you guys to get my visa? You can't. This is one of those cases where if you're not in the litigation that's successful, you're not in. There's no way around it. So I mean, if you're a DV 2022 winner and you're relying on the good faith efforts of the State Department to get your visa, your beliefs are mistaken. Because it's quite clear that there is no good faith effort by the Department of State to get you their visa.
Yeah, I mean, it's always our hope that we'll get a broad order that'll help everybody, not just our plaintiffs. But the fact of the matter is, last year it was just the plaintiffs that benefited from it, and we don't have control over that. That's up to the judge. But we can't, if you're not, Chuck's right. If you're not in, the only way that you can at least be assured that you'll benefit from the litigation is to actually win litigation.
So you got to be in it. So join. We'd love to have you and get this done. We know there's at least one other group that's doing litigation. More power to them. More the merrier. But we're going to just wait a little bit longer, get some more of our plaintiffs on, and look to file this next week. So that actually brings me back to the goings on in the Go DV 2021 lawsuit. While I was, basking in the glow of my vacation, I still was on my email because I literally only had my phone. So literally I'll have my phone with me. And we got an email from government counsel that said that they had permission to move forward with the appeal from the Solicitor General. Greg, what do you think about that?
Well, I think it kind of dashed our hopes that maybe they were feeling a little guilty about claiming to be pro-immigration and liking the DV program, while at the same time, they ultimately made the decision to try and deprive thousands and thousands of people of visas that a judge had already ordered. And they've yet to publicly explain why they're taking that position. Everything that's happening is sort of like cryptically happening behind the scenes, and nothing coming from the administration saying why they're fighting this. Fortunately, there's been a number of media reports on it, and I think that they're getting, that at least they're getting some heat from not just from litigation, but from the public. But not holding my breath that they're about to change.
Aaron, what's your take on the government's position here?
I'm at a loss for words for the sustained attack on the diversity visa program. I can't explain it. I would say, just to give a little bit more detail on what's going on. So they are going to, one, like Chuck said, they're going to proceed with the appeal. But two, they're going to seek a stay. And to do that, they first need to seek it from Judge Mehta. If he denies it, and of course we'll oppose, if he denies the stay, then they can seek a stay from the DC Circuit. And it's, by no means a sure thing that they will get it from either court. And if there's no stay, then they still need to process the visas by the end of the fiscal year. If there's a stay, they can get a stay on that relief. Now, it's interesting because, like Chuck said, in regards to the DV 2022, what they said was we're processing, even though the data shows it wasn't true, we're processing all the DV 22 people we can early this fiscal year so that we're ready to do DV 2020 and 2021 pursuant to court orders later in the year. And now they're saying, well, actually, we need a stay of this relief because otherwise we'll suffer irreparable harm for having to put together this.
They will suffer.
That's what they're saying.
Government will suffer irreparable harm.
So what's going on? So my question to them is, well, so have you updated your systems to comply with the court order? If so, then what's the harm in going forward and processing them? If you haven't updated them, then why are you telling Judge Mehta in status reports that you're hard at work on it? So, I think we have a lot of questions about how they're going to frame this request for a stay and why this is irreparable harm to the government. But they have not filed for the stay yet formally. They've told us that they're going to. So
let's just tell you, I think one of our other colleagues out there may have posted in their own case the government's position, but let me just tell you what they said is they intend to move for a stay because the order requires the Department of State to engage in resource-intensive actions that disrupt its normal consular and immigrant visa application processing operations. That's not true, by the way. And they already told the court they were spending $500,000. Isn't that what they told the court? It's going to cost them $500,000 to change a date in their program to issue visas. I mean, that's the kind of contract I want to get if I'm a government contractor. I mean, that's going to take them at least 30 seconds to change that little code in the line to let them change it up. But here's what this is actually the key part that also goes to DV 2022, because it's the DV 2022 is based on the fact not that there's a ban in place, but they are illegally prioritizing visas, which Judge Mehta has said in our case that is illegal to do. Figure it out, but it's illegal to prioritize. But here's what the government lawyer said. further, the order undermines the Secretary's discretionary authority over the prioritization of the state's finite resources to support consular operations. What does that mean in human speak? Yeah, we don't want to do them. We don't have to do them. You know, just because Congress told us to do it, we don't have to do it. Greg, that's illegal. That's illegal.
Right.
As the executive branch cannot not do the job that Congress has told them to do.
Right, and they can't. Right, and they can't just say we're going to work on the stuff we want to work on because we want to work on it on there. Unless Congress said that they laid that out, that's not something that they can do. I am curious as far as whether the ultimate motivation here is that they just don't want to. This is all about power, and this case is about power. I mean, you could argue, being generous with them, that they don't really have a problem with DV. They have a problem with losing in litigation and being told by a judge how they have to that they have less authority than they would like to have. So I guess I shouldn't be too surprised, because it seems like that's one consistent thing you see from the Justice Department, from administration to administration, is that that they answer to the White House, and that's always their priority, is to preserve presidential power.
Now, I did respond to this email, and I'm sorry I didn't consult you guys before I sent my email.
Loved your response.
But I did say, and I think I responded within looking at within an hour. I had responded, probably because I was not looking at it right away. We vehemently oppose. They asked if we would join them in a stay. We vehemently oppose. Your side lost, and your client lost that specific argument. Your client should do the right thing and issue the visas. And so you are aware, we will seek attorney's fees and likely sanctions, because such a filing would be in bad faith, especially since your client has unreasonably delayed the appeal, saying that Secretary Solicitor General has not even decided to approve the appeal. Act accordingly. Now, I think they're going to ignore me, but man, I was pissed off. And then, of course, the next day we get a similar email in the Aker Gomez case for DV 2020. Now, of course, we only have 2 plaintiffs left in DV 2020. I mean, that's all we have left in that case. So we're still, peripherally involved in that case. But they sent the same email, and I sent essentially the same email to a different government lawyer. So we'll see what happens with these 2 cases, but it's extraordinarily frustrating to be told, one, if you make us do this, we're going to be harmed. Now, what I would like, Aaron, what do you think about this? I would like our clients to email us how they are harmed by Department of State not issuing their visas before September 30th, 2022. What do you think?
Yeah, and I think we can probably get some kind of update form out to.
I think we should do that. I think we should do an update form from our plaintiffs saying, how are you harmed? How have you and your family been harmed by Department of State not following this court's order in a timely fashion?
Let me just ask you and Greg this other question that is bothering me a little bit. So they say, I think, I kind of agree with Greg. What he's saying that is probably the real motivation is that they don't want to have these court decisions, which they think take away from executive authority and extend statutory deadlines and whatnot. And fine, whatever, you make your arguments on that, and we'll see who prevails. But what's bothering me is they can still do that and try to vindicate what they think is their authority in court and not stay these. It's really not that many people, not stay these visas from being issued. And so to me, it seems vindictive to seek a stay during this litigation. It seems unnecessarily cruel. They could issue these visas while they still try to vindicate their rights in the appellate proceedings. And they say, it's too expensive. It's, it's been more expensive to do all this litigation to the government, far more expensive to continue in this fight than it would have been to comply with the law in the first place. So I don't have a lot of sympathy for for them on that, and I'm as you can probably tell, pretty dang frustrated for our plaintiffs that they're going to try to keep them out.
But it's a fight that we have to have. We brought the fight because we know we're right. We won the fight because we're right, and we will keep fighting this fight because we're right. To me, it's unconscionable that they would do this. Absolutely unconscionable. For us in the Go case, it's 465 visas. Now, as everybody knows, we're appealing
481.
that. Yeah. So we're appealing that. But, if the government just issued the visas, the appeal would be over, I think. But how long would it take for them to issue 461 visas at 70, 80 different consulates around the world? You're talking about a day.
Mm-hmm.
It's a day. One day. That's what it would take to comply with this court's order. We will make that clear to the judge, by the way. It's one day. Especially now that the consulates do all the work, right? So just get to the consulate. Here's my stuff. Boom, boom, boom. We know that they're taking, 15, 20 minutes on these cases at the most. And if to comply with the Gomez order for 9,000, okay, that'll take them 10 days. They could do 500 a day. They made that.
But we know in September 2020, when we had in the Aker and Gomez case, they were able to do 5,000 of these in a month on there, and that was during the middle of lockdowns.
Right. So we know they can do it. I mean, it's fully capable of doing it. I think Greg is absolutely right that this is about power, and phrasing this as the secretary's discretion. First of all, Tony doesn't know jack squat about this. All right, let's be clear. The secretary's discretion here is not about Tony Blinken saying we shouldn't do these. These are career bureaucrats making this call on this. Now, if Blinken had any big backbone, he would back up Joe Biden's promise to make the DV lottery great again. And he didn't use those words, but that was the intent. Instead of just sweeping it under the rug. Guys, this is the other concern here. The consulates, have they gone back to issuing every type of visa, or are they still basically just issuing immediate relative visas around the world?
Well, the data is clearly showing the immediate relatives are processing probably at a pre-pandemic pace at this point. So there's no problem happening there. The question is what's happening with the rest of the numbers.
Right. And so I'm getting calls from, F2As, F2Bs, spouses of permanent residents, just been waiting 2 years still, nothing.
I had heard that employment-based consular processing of immigrant visas had been that had picked up a lot.
Well, I can tell you a couple of things. So as of the December data, we were on pace to see 440 thousand total immigrant visas issued. And in 2019, they issued pre-pandemic, they issued 462,000. So it's at about 97% of pre-pandemic capacity across all categories.
Right.
So,
which probably means what's happening, Chuck and Aaron, is that they are clearing backlogs, but ignoring DV.
Well, at the expense of DV. They're clearing backlog at the expense of DV, thinking It's just not and why is that? Where is the political voice for diversity applicants? We know, employment-based visas, I'm sure the Chamber of Commerce is all over Tony Blinken and Erd Jadu saying, what are you doing? USCIS came out and says, we will issue every single EB visa this year. You're welcome, in the words of Maui from Moana. You're welcome. That's the lawsuit that we filed in September that they now come out. We will issue every employment-based visa. What he's saying is, Chuck, Aaron, Greg, don't sue us. We're going to get all these done. I promise you're going to get all these done. And I'm sure they put pressure on the state. That came from the Chamber of Commerce and from the lawsuit. But the consulates, it's just very frustrating for people. And just to know, we share your frustration and we're fighting for you. Guys, anything else on the DVs? All right. So once again, just a reminder that you can sign up for DV 2020-22 still. And we're hoping to get this filed next week. All right. Now, the next big deal, Aaron, that came down was in the Kang case. The Kang is the EAD case. You want to give us an update on the EAD case?
Sure. I think as of our last update, we had just filed our opposition to the motion to dismiss and motion to transfer, and the government has since filed their reply, and so the court is sitting on the motion to dismiss or transfer that is fully briefed, and the court can either set a hearing or issue a decision at any time now.
Who is the judge in the Kane case? Do you know?
Judge Leon.
Oh, cool.
Richard Leon, yeah.
Cool. What is the government's reason for moving to dismiss, Aaron? What's the motivating factor here?
Well, their asserted reasons are that there are the track factors, so that there's not enough delay basically on all the factors. But basically, they don't want courts getting involved in telling the agency that they're too slow. That's basically it.
So where are we on the class action component of that case?
That motion, the deadline for the class action is coming up, and it's in draft, and we will be filing it this week.
Awesome sauce. All right, so that's the EAD case. Now, the next big case, all this is like cavalcading on top of us, cascading on top of us, is the H-1B lottery abuse case. And we've been asked to use that term rather than the name of the case, and we will do that for our plaintiffs. The H-1B lottery abuse case has come to a roaring, exploding head right now. The court ended up allowing the interveners to come in. This is the IT Serve Alliance, which, by the way, has another case pending with this same judge, by the way, on a different issue, as the interveners, because they would be negatively impacted if we prevail, because they wouldn't get to presumably file as many H-1Bs as they want, in the H-1B raffle process that currently exists. So we filed. I thought our brief. I thought Waleed really working with all of it. I think that's a great brief in opposition to the government's motion for summary judgment on our reply. What do you guys think?
I do too.
Yeah, no, it was very strong, and I think that this is a common sense thing. This case. I mean, if you set aside all the legal arguments and everything like that, you're just basically telling the judge, look, we have pretty strong evidence that there's massive abuse happening in this program, and the government is ignoring it. Judge, you need to step in and fix the issue on here, and that's bottom line what it comes down to. And I just don't see the government at this point. They don't have a compelling counter response to that. IT service, basically it's the same story with them. They still don't have nobody's basically saying there's nobody really saying there's not a problem. They're just saying that they shouldn't be sued to be able to deal with the problem.
The IT serve guys don't even mention the fact that there's massive amount of abuse going on. They just say it's all about the money. This is just way cheaper for us. It's way cheaper.
What about what did you make of the government's announcement that they were requiring a new amended attestation?
Well, I'm not sure. They told their legal counsel they were doing that announcement. So on Friday of last week, thankfully Friday during the day as opposed to Friday after we filed our response, which was filed 11:59, they issued the announcement, hey, registration is March 1 to March 5, as we had previously told the judge it was going to be, and why the judge forced us to get this all done very quickly. He believed us. We needed a decision by the end of February. And what was interesting about this is here's the what you have to do is basically a how-to. How do you register? How do you enter the H-1B raffle? All right. How do you do that? And buried within the pre-existing attestation that an employer signs, saying it's a bona fide job offer, is this additional paragraph, which sounds suspiciously like it came from our lawsuit. I certify that I am not aware that other people are applying for this individual. But the thing is, as our good friend Angelo Pepperelli pointed out, this is signed by the employer.
Right. Why would the employer know? Why would you tell an employer that you just asked to file for you, by the way, I have 10 others pending, so it's not very likely that you're going to be the one I'm going to go with if I get selected by 3 or 4.
And for legitimate employers, that's true, Greg. I think it's in the context of these job shops that are just filing. They have 4 different companies, and they're promising to file for each one. I think it's designed to catch them.
Right.
Now, remember, it's on the penalty of perjury, right? So if they can say, well, you have 5 related companies, you're all signed by the same same person as the secretary of each company. You all sign the same ones. You've committed fraud because you checked yes to that box. Right. So maybe that's why they're doing it.
And that's good on there. I don't think we have a problem with that. It just doesn't address the fraud that we are complaining about in our lawsuit, even though I think it's very likely that the government is going to tell the judge that they've addressed the issue now, and therefore it's moot, the case, because they've already, here, Judge, here's how we've already just fixed this problem. So that's probably what's coming.
What's also interesting is the 90-day period in which raffle round 3 H's have to be filed ends February 23rd. So that means we should know by February 24th whether there's going to be a 4th lottery.
Mm-hmm.
And we have made that point. We statistically showed the judge that it's highly likely, and the government didn't say anything. Unlike the motion to dismiss, in which they submitted an affidavit that says, no, they're not going to be a second line. We're done. We got.
Out of curiosity, could they, just to be jerks, just not do a 4th lottery, even if there are numbers? Could they get away with that?
Somebody has pointed out that they don't have to issue every H-1B.
Yeah.
So yeah, they could do that. They could say, well, we issued 63,000. Close.
But they still have to release the data.
Well, that's the thing that's the data that's not being released, right? How many people that were selected didn't file H-1Bs?
Yeah.
They told us how many they received, how many raffle registrations there are. They told us how many were invited to apply in the raffle, to apply the H-1Bs. What they haven't told us is the I don't know, what do you call it? The no submission rate, the non-filing rate upon selection in the raffle.
Yeah.
So that's what we don't know. And that we kept pointing that out in the brief. The government is not telling us the data. Now the government's response is, hey, this lawsuit's only about the APA. That's not true, by the way, but that's the government's position, which is fine for us, because if this is only an APA suit, I think we win. I do. They were told about a serious problem by almost 30% of the commenters, and they didn't address it. They just blew it off. If nothing else, I think that's where we win. But we'll see. We'll see what the judge does. The judge may agree that, it's all about the money and the damage is too much if I undo it. But let's say we win. Greg, if we win and the judge says this regulation is unlawful, I strike it down. What happens?
Well, they have a choice. They can either revert back to the old system, or they can fix the issue and just change the algorithm so that it's one chance per person.
How fast could they change that regulation?
I think
not that you're an APA expert, but could they do an emergency rulemaking and do it in 30 days?
I think so. And there's not a deadline that comes down from Congress of when they have to actually hold the lottery. They have some flexibility here. They just have to have it so that they start issuing these visas on October 1st on there. And, so I'm not that part of it doesn't worry me, but I what I can probably almost promise you is that no one at USCIS is working on this with in the contingency, that they might lose this litigation. I can promise you that they will not deal with this issue until a judge tells them that they have to deal with this issue, which is also pretty irresponsible.
You and I could write this new reg in an hour and get it off to OMB in an hour. This is not that hard. It's a minor, tiny change that makes all the difference in the world. But I'm really interested to see if we lose the lawsuit, how many H-1Bs are actually going to be filed in the raffle? How many registrations will be in the raffle this year?
Yeah, well, that'll be interesting. I think one of the, one of the things that I found most fascinating when I was going through the administrative record is that there were various comments that were coming from USCIS in response on employer fraud that was happening as far as multiple applications for the same individual by a single employer. But when it was pointed out to them that the reverse can happen, where you can have a individual file a large number of applications by multiple employers, and that's seemingly legal under the way that the regulation was drafted. USCIS, their response was, well, that's the statute allows for that, so we're not going to do anything about that. That's not our problem. That's something Congress can deal with that if they want to. But that's not in fact true. They still have to. Our argument is that that's not what the statute actually provides. The statute provides one visa per person. So that's their response, is that not that they are doing the job of preventing fraud. They're just saying it's like, well, it's not our problem.
I agree. All right. I wanted to just circle back to the EB delay litigation. Yes, we did not win that in September, but we won that war because now they're promised to issue every single EB visa this year, which is important. That's 380,000 EB visas. I think it's 380, maybe it's 360. I think it's 380,000. But here, what about next year? Near as I can tell, and I'm looking at the numbers on CEAC, most family-based preference category cases are consular, as opposed to most employment-based cases are USCIS adjusted. So if the consulates are not doing pre-COVID levels of family-based cases, there is likely to once again be another substantial rollover for fiscal year 2023 into the EB category if Congress doesn't do anything, right? So this is fascinating because this is actually great for all the clients we represented who will be approved, because they have more visas available in the EB category on October 1 than they had cases filed. They had more in their hands. So, ultimately what this means is by mid-year, we'll see some movement in the visa bulletin for India and China. Hopefully that's what that means. Anyway, I just wanted to add that in here. On our K cases, as everybody knows, we filed a withdrawal. We put a suggestion in case. What I have found fascinating, gentlemen, recently, I have in several listservs that we're on involved litigation. It's come up several times that people are waiting for decisions from judges and how to push them. The universal answer always is you can't push a judge. But it's not just these cases. There are a lot of cases out there in the immigration sphere, at least, in which there's just not getting decisions made. So we're fighting for you guys. We're just kind of stuck in this moment before we can move forward. So there we go. All right. Should we take some questions, gentlemen?
Sure.
I think we got some questions here. Let's see. I'll go to the top here. Grumarco, he was on early. Do you maybe know if DVV's recapture will be part of the chunks of the Build Back Better instead of the vote on? Hello from Serbia, Grumarco. Hope you're doing well. Greg, you were chatting a little bit ago about this before we went on the air. Where are we on immigration reform?
Well, there's a couple of things that are going on. One is that there is the Build Back Better is kind of in this quiet behind the scenes negotiation that's happening with Senator Manchin. The president referenced that this might be broken up into a number of bills instead of just one big bill. And there have been, there's been chatter by members of both houses about trying to still attach immigration if one of these is going through a reconciliation approach and just, overruling parliamentarian. But there's nothing concrete that we can point to right now. There's just a lot of chatter that's happening. My guess is that sometime this month, it's still early in the month, that we will see some news as far as where we're going. My understanding is that Senator Manchin is basically, the ball is in his court to figure out what he wants. And when that becomes known, then this legislation will start moving. Now, I think what's also interesting is a separate piece of legislation that's coming from the Rules Committee. This it is this America Competes Act, which has some significant immigration provisions that are in that bill, including basically uncapping the green card category and also having a startup visa in there. And that bill I actually have more optimism for that, because that's the kind of language probably that GOP members might be willing to support. At least they say that that's the kind of stuff that they want. But, with any of this stuff, until you can find 10 Republicans that are willing to sign off in the Senate on it, it's not. And when you find any bill with 10 Republican co-sponsors in the Senate, those bills might move. But until you see that, the only way it's going to move is through some budget reconciliation, and that's going to happen maybe one or two times this entire Congress.
Thank you, Greg. Luca, good to see you too. Karen, it's a great question. Given the government's announced the dates for the e-registration, which we knew they were going to, we knew that was going to happen, can the outcome affect this year's lottery? The answer is yes.
Yeah.
The judge actually issued a very specific order this Friday. The record, basically what the judge is going to use to decide the case, is being filed on Friday. And that's basically just the regulation and the comments. There's really nothing else in there. And the government's reply and the reply of the interveners is due Friday. And then briefing's done. So then it's a question, is he going to have oral argument? We don't know. Is he just going to issue a decision? I don't know. I've had oral argument with this judge before in this case early on last year. He might do it. He might not do it. I don't know. I don't know if he did it in person, if he does it on video. We don't know. But he made clear the parties would like a decision before March 1st. So he's clear he's aware of it. And I do expect to get a decision by then. And that will impact the registration if we win, certainly. But look, registration's in March. You can't file until April anyway. So the registration is put back a month. Who cares? I mean, you just can't get it in anyway. It's no big deal. We do have a lot of friends, though. We're immigration lawyers. I mean, we do H-1Bs. We all file H-1Bs for our clients. Yes, it would be wildly inconvenient to have to change how we do it. We get that. But immigration could make that uninconvenient. They can make it convenient again easily if they want to. So people are like, do I register? I said,
Chuck, we file H-1Bs, but for almost all of our clients, that they have been negatively impacted by the odds of their key people that they're filing for being the odds of their winning being dramatically reduced because of all of this fraud that's going on. They will bet our clients, as most H-1B companies in the United States that are filing this stuff, will benefit by having a fair system.
Right. All right. Great question. Filing the lawsuit. We talked about it earlier. Aaron, that's next Friday, kind of the goal. Do we negotiate with the government? I'm sorry, I'm laughing. Aaron, are we going to negotiate with the government on the DV 2022?
Well, we will not be doing pre-filing negotiation. As soon as we file the complaint, just like last year, we'll be in touch and talk about an expedited briefing schedule and do some negotiations there. But before filing this, it's not worth anybody's time.
It's not worth time.
They also, it would be nice if they reached out to us a lot more frequently to negotiate solutions so that we didn't have to take this litigation quite as far as it goes. But they never seem to have their act together to be able to have that kind of discussion until they don't have a choice.
Yeah, so it is. I don't know how many plaintiffs we have up to the current time. We'll announce that next week. We get that. Do not postpone. We're not postponing it. We're just getting the best lawsuit possible, Paul. Don't worry. There's plenty of time. Talked about Go earlier. DeClorox, Abdel Samad. When is the government chance for it to stay the order? Somebody asked me that on Twitter yesterday, and I said that you cannot gamble in Las Vegas on the outcome of a case. You probably can, but we don't. I don't know. So it's either a yes or no. It's like it's a binary, right? It's either yes or no. So I don't know. I would be extremely saddened if Judge Maida. Now, keep in mind, they're going to do this twice. So if Judge Maida says no stay, and I think he's inclined to say that because they already asked for a stay. They asked for a stay in oral argument on September 30th. They wanted a stay, and he said no, right?
Yeah.
So why would he change his mind? There's nothing, literally nothing has changed. In fact, the Department of State has made the conditions worse on themselves and DD Lottery since September. So then they will then ask the Court of Appeals for a stay. And I don't know. At that point, I don't know. That's up in the air. So So just don't be surprised. Lucy the Maverick. This is a great question. Greg, do you want to address this whole transfer underlying basis, interfiling stuff? Are you aware of that?
Yeah, so I guess that it's good that they have, I think that they have provided more clarity, because there had been a lot of confusion in the immigration bar on how we were supposed to manage this process, where we have people that, their fortunes shift depending on what's going on in the visa bulletin, and they may, they may be better off moving to the other category, but it's never been clear exactly how the government wants us to do that. So I think now, I guess the money grab part of it is, I think you have to file the supplement J form with a fee in order to be able to do this. I think on there, that might be where this is coming from. I don't think it's necessarily, they're not asking for a new adjustment application. They're just asking, I think, for the,
there's no filing fee for supplement J.
So then I don't understand. Yeah, so I don't understand.
It's not a money grab. It's actually, I think it's done to make their life easier, because the current interfiling system is not really a system. It's mail that randomly comes in. And if you file a supplement J, it goes through a certain process. It gets in a certain place.
Right. So we're filing it at one central location now.
Yeah. And I think this is really for their convenience. So it's cost, other than, of course, the money, lawyer's going to charge you to do it if you're going to use a lawyer to do it. But it's you don't have to do it if you've already asked for interfiling into the old system. But we're advising clients in this situation to go ahead and file a supplement J, even if we have previously filed for the request, because we just double doing it to make sure they really get it, because we just don't trust the system.
I know. But the comments I've heard overall are, this is probably good news.
Yeah, I agree. It's a good thing. I think it's a good thing. It's one of the very few good things that they've done.
Well, we've seen some good things in the last couple of days. I mean, I thought
I have a list of 15 good things they haven't done yet, Greg.
This is the time of the year I have to really crank up on updating the cookbook that I do, and so I'm doing like a lot of late nights and a lot of writing right now, and I've had all these policy manual changes that just got dumped on us that have to be incorporated.
Well, what's funny with Greg, when they do that, they announce policy manual change in this section, but they don't tell you exactly where.
That's why I have the Wayback Machine. So I go back, I literally do my own redlining. I go back and I find out what the policy manual looked like the day before the changes were pushed out on there. And I do my, so I have in here everything that's new. And there are some really positive changes, I think, especially for STEM professionals, as far as the O1s and national interest waivers go. That doesn't really help Indians that much, who are a lot of our clients in the national interest waiver category, because that category is so backlogged. But it does help EB1, and it does help O1. It helps also the STEM. There's 22 new STEM occupations that are there, which gives a lot more people more shots at the H-1B lottery. So overall, I was pretty happy about that. And we were also just talking about sort of a sleeper announcement of this executive order, which was also on January 21st. And not too many people are talking about that, but because it's vague on there. But it basically, the White House issues this executive order, basically telling the government agencies, and this is what I was just looking at beforehand, this executive order, that they have 90 days to, the Secretary of State the Attorney General, which is in charge of the immigration courts, and the DHS Secretary to issue this report about what they are going to do to reduce barriers to immigration benefits and ensure efficient adjudications of those benefits and remove those barriers as appropriate. Now, that is super vague on there as far as what that means, but it does sound like within 90 days, we're going to get some fairly detailed announcements probably on what each one of these agencies is going to do to clear out these backlogs and to make the system fairer. Now, that's the optimist on there, but I don't. Chuck had more of the cynical view when we were talking about this before the call, basically saying it's like, yeah, this is just basically so they can tell the judges in these cases that they're really doing something. But I don't think that executive orders typically, they do seem to have an effect. I mean, I remember the Baja executive order from Trump. When I looked at that thing initially, and I was like, this doesn't look too bad on here, because it was super vague and it didn't really say what they were going to do. But they used that executive order and they took it to heart, and they issued a million different policies citing to Baja that Trump executive order. And when the White House bothers to issue one of these things, it's supposed to set the tone for how the agencies are going to act. And it seems like they maybe are getting the message that there are serious adjudication problems on the legal immigration side, and that this is the message to the agencies is, I'm expecting major changes to fix this, and you have 90 days to tell me what you're going to do.
How about stop interviewing employment-based cases? How about
well, that's probably that could be something that's very well in there, or video interviews that we've been harping on forever at the State Department that they could be doing. All these things that we talk about every week that they should be doing. They could, a lot of those things could end up in here. The other thing that I was having a conversation this past week with an advocacy person who works for a national organization is, what happened to all of those April and May suggestions that we put in? You guys may remember that there was a sort of national suggestion box for how to make the how to remove barriers. And this was done by DHS, not State Department, but there were 7,000 of these suggestions on there. And it's like, and I was asking this advocacy person, it's like, I just looked at a couple of them, that were coming from the big organization. There were tons of great ideas in here. And I don't know, like with 7,000, there's got to be a million pieces of gold in there on there. What happened to that? And my guess is that wasn't just an exercise for PR. On there, I think they do want that. There is somebody. They have contractors probably who their job is to tally all this stuff and come up with a list of what is doable and what makes sense. And that could be that a lot of those things could be in this report that comes within 90 days.
Let's hope it's something more than a fee increase across the board.
Well, the regulatory agenda, by the way, came out yesterday.
I saw that, and it didn't have
nothing in there except for the fee increase. So it's like, where's all the good stuff that's supposed to be coming?
Where's the DACA? Where's DACA? Yeah. Why are they not publishing DACA?
No, so we'll have a better. I think we'll have a better sense. Maybe they are holding some of that stuff back until this 90-day report gets issued, as far as what they're really going to be working on.
What's up? All right, Jason Claus. Are the embassies supposed to be clearing the backlogs in order? Aaron, what do you think? I don't know what we have no idea what they're supposed to be doing. Basically, state has said publicly, our official prioritization is canceled. Do what you will.
Mm-hmm.
That's the order. Do what you will.
They always say when they're defending these suits that if this plaintiff gets to go now, that they're essentially jumping ahead in the order ahead of somebody else. So they claim there is some order on there, and it's not just random. But we have no evidence that that's actually how it works.
Yeah, none. And they've produced no evidence to prove that. By the way, they've just averred that, but they have not proved it. Lucy is back again. Look, they have to use 380,000 visas this year. And they have not published. I mean, I haven't seen first quarter numbers from the CIS. Have you guys seen first quarter numbers from CIS? No. So they haven't published it. So we don't know how many they use in the first quarter. So yeah, EB2 dates are moving, EB3 are not, because they took in so many EB3 applications. And Greg and Aaron will laugh about this. How many people that are your clients had EB2s downgraded to EB3 over the last couple of years? That's the problem. They actually have a lot of cases pending that are in both categories.
Yeah.
So there's not really as many applications filed as are actually filed. So there's that. What about Go's counter appeal, Aaron?
Yeah, that'll be on the same schedule as the government's appeal. So we don't have a briefing deadline or anything like that yet. We expect to have more updates pretty soon, I would think.
Yeah, Aaron. I mean, one of the things we, initially we had to make strategy decisions regarding appealing the number of visas that were reserved. That was a question that, and we, it was one of these things where it's like, well, you risk losing everything if you appeal. So but now that we're kind of stuck in this situation, we actually have an opportunity potentially to expand on that number, since the government's basically, they're the ones that, this is a situation created by them. So we will certainly try, and I know we thought that the judge's methodology was flawed in terms of the numbers, and it should have been a much higher number. So now we'll have a chance to make that argument.
Rajul, your dependents should hopefully be approved this year sometime on their adjustments. If you were a Chakrabarty plaintiff that was approved. Does Go will join Goodluck case? Yes, there will be, the appeals will be heard together.
Mm-hmm.
So hopefully that answers your question. I mean, it makes sense to hear them together, although we will be fighting independently for our clients. Okay. Soo Young Kim, how many plaintiffs in Kang got the EAD approved in the meantime? That's a good question, Aaron. Do you happen to know how many we still have active?
I don't have that in front of me. The last I looked, there had been,
about half had been approved, right?
Yeah, it was getting there. And so people are getting approved, but I don't have the exact number.
11 months is unconscionable. It's unconscionable. It's no legitimate explanation about how that's not harmful. I mean, they even acknowledge it's harmful because they don't, if they say, oh, your EAD is good forever until we get to it, all right, that solves the problem. But it's not. It's 180 days. So what good is it then? It's just outrageous. Is a Biden administration to harsh immigrant really thinks will help them politically? Casey, if the Biden administration thinks this, they are morons. They're morons. That's all.
Yes,
I have
the
to
answer
say
is
about
yes.
That.
The answer is yes.
Yeah. But they're morons if they think that. Really.
Yeah. I don't know. It's like political malpractice. I really want them to, we all want them to succeed, but they just seem to blow it over and over again.
Tell you, Democrats could screw up a one float parade. I'm just telling you. Any updates on H4 EAD premium processing? No, the premium processing reg is not in the update.
Well, they did have so there was something that did happen over your trip, I think, Chuck, and that is that one of the things this all comes from this bill that Congress passed to basically avert the shutdown that was threatened by USCIS if they didn't get a big check written to them. And in there, they had a lot of things that were in there, but one of the things that they had in there was a requirement that within I think 180 days of the bill, they were supposed to issue a report on electronic filing. And I think that their feeling was at the agency that they couldn't implement premium processing until they had e-filing procedures to pave the way for that ahead of time. And that report finally did get submitted, which was helpful. The other thing I think that came out was, I think there was an Office of Inspector General report.
There was.
That came out as well about delays. And one of the things that they pointed out, which was telling, and and I think it relates to this, is that the naturalization process had been going remarkably well as far as that staying on a relatively steady clip as far even during the pandemic for those applications. And I don't think you'll hear too many people griping that naturalization's processing times have fallen off the cliff. They haven't on there. They have switched over to the Ellis system for filing naturalization applications. The claim system, that's the old system that's been around since the 80s. That's what is still largely the system that's used for most of the benefits that are going to, including the H4s and all of that. That's still in the old system. And I think the feeling is that they can produce the same kind of results that they've been able to get with naturalization once they have e-filing available, that they can get a lot more of it managed with data entry without having to retype everything, which is how it works right now in all these other processes. But that is, so I am actually, and there is a reg that was sent to OMB, I think in December, for the premium processing reg.
Right.
It's already been sent. So I actually do think we're going to probably we're going to start seeing these processes happening in the spring. I think what will probably happen is it may be as early as this month that comes out of OMB and publishes, and then there will probably be a 60-day wait on until they start implementing it, which would take us into probably April or May. But I do think we're going to see it this spring.
Just ticks me off. If the court grants the stay, that means no visas will be issued in any of the DV cases until the court decides the case, which could be 6, 8, 10, 12 months later. That's what that means. Mm-hmm. It's not a good thing. It's not a good outcome. Let's see. If you file a supplement J, do you lose the benefits of no, you do not lose the benefits. No, absolutely not. No, there's no doing the supplement J is a good thing. You should do that. How many plaintiffs in DV 2022? We're going to assess that and talk about that next week. I just know on top of my head. And finally, hi, great lawyers. Well, hello to you, Bijarsa. All right, everybody. It's been a great week. You guys have any other final comments here before we close up shop on this week's update?
No, I am back on this week at 1 for Facebook and Twitter.
I have to get a new date for my Facebook, Twitter, because I teach Wednesdays from 10 to 10:30 to 12:30 and 2 to 4. So it's made at Emory, and they're back in class this week. So at the law school, so I have to figure out what my new date and time is. All right, you guys. We'll see you later. Have a great week. We'll see you next week.
Bye.